All right. Speaking of federal cases, in episode 9 of the podcast, Jeff, we discussed the importance of Rule 50 motions, which are necessary in federal court to preserve issues for appeal. And as if on cue, right after we released that episode of the podcast, the Ninth Circuit furnishes a helpful recent example in the case Brown versus County of San Bernardino. Brown, in that case, sought a civil rights claim against the sheriff's department, but the claim failed on grounds of qualified immunity. The court held that appellant's failure to make Rule 50 and 59 motions, those are motions for judgment as a matter of law and motions for new trial, the appellant's failure to have made those timely motions in the district court resulted in a total waiver of her substantial evidence arguments on appeal.
Right. So even raising it, even if she had raised it in her opening brief, the fact that she didn't make the appropriate motions under Rule 50 and Rule 59 preclude the Ninth Circuit from reviewing the issue.
Right. Yeah. So if you're in federal court, do not forget to make your Rule 50 motions. And in fact, because Rule 50 motions must be first raised orally in the trial court before the matter is submitted to the jury, it might be a good idea to prepare your list of anticipated Rule 50 motions before trial even begins, so you're not caught flat-footed having to think about what issues have been raised that you need to put on the record in a Rule 50 motion.
Or better yet, have your appellate counsel in the wings ready to draft an appropriate Rule 50 motion that preserves the issue for appeal.
Well, I wasn't going to say it, Jeff, but I'm glad you did.